This particular case, not surprisingly, did find that by marking correspondence as being subject to contract, that prevented a binding contract coming into existence. So here you had some settlement negotiations which were conducted through email exchanges, and at one point, one of the parties sought to claim that there was a binding agreement that had come into effect. But the court said that the subject to contract qualification had not been waived by the parties. It still meant that it prevented a binding contract coming into existence. What the court said was that where negotiations are carried out subject to contract, the mere fact the parties are of one mind, in other words, they've reached agreement, is not sufficient for there to be a binding contract. There has to be something more than that, a clear act or a clear factual basis for removing the subject to contract qualification. Now, that's obviously useful because it means that you don't inadvertently find yourself subject to a contract. But what I would say is you do have to be very careful, because there have been other cases, other previous cases, which have found that if you act as though the contract is in place, even though your correspondence has been marked as subject to contract, there is a risk that you will be held as being bound into a binding contract. So a subject to contract qualification on correspondence is useful, but you cannot absolutely guarantee that that will be effective if you've gone off and acted as though the binding contract is in place. Another example of being careful regarding inadvertently getting involved in a contract is in the Nautica Marine case. Now, here there was some exchange of emails, and I've quoted on the slide the key point. This was a ship charter, and it said, "We are pleased to confirm terms of the following fixture concluded on the 8th of January 2016, subject to various charterers' approvals." Now, the question here was that a precondition to a contract coming into existence? In other words, did those approvals have to be obtained before the contract came into existence? Or was that saying, well, we have a binding contract, but part of the actual performance of the contract is the obtaining of those approvals? Obviously, if it was a precondition, then it would prevent the contract from coming into existence. But if not, there would be a binding contract and there would be an implied obligation on the parties to take reasonable steps to satisfy the condition. What the court said, and this is really the reason that I mentioned this particular case, is the court said determining whether a contract has been formed depends not on the subjective state of mind of the parties, but upon consideration of what was communicated between them by words or conduct. So in other words, it doesn't matter whether you think you are in a binding contract or not. It is whether what you did and said in correspondence would leave an objective observer thinking that there was a binding contract in place. So you have to be careful that you make your position very clear, possibly using the subject to contract statement. But as I say, if through your email exchanges or by going off and acting as though a contract is in place, it is possible that you will be bound into a binding contract. One of the other key lessons, particularly in an IT context, is making sure that any terms and conditions that you want are validly incorporated into the contract. Now, in the kitchen components case, there was an order placed by the customer simply by issuing a purchase order. And here the supplier acknowledged the purchase order and referenced that they wanted their supplier terms to be applicable. The acknowledgement referenced these terms, but there was no actual evidence that these terms were actually supplied. The supplier in this case made similar references both in delivery notes and on invoices. And the point I would make here is that normally, if you only refer to terms and conditions in delivery notes or invoices, normally that will be too late to make them incorporated. And the reason for that is because the binding contract comes into existence when there is an offer which is accepted. And normally that's before the delivery note or the invoice is issued. The court said that what each party was reasonably entitled to conclude from the acts and words of the other is the key thing. Now, normally what I would say is it's very important that if you want your terms and conditions to bite, you have to make that very clear before you accept the other party's offer. So if you exchange emails, for example, and you haven't referenced your own terms, then it may be too late to incorporate them subsequently. Here, the court was relatively generous to the supplier in this particular case, because they said that even though they hadn't supplied the terms, they had at least put the buyer on notice that they wanted their terms to apply. And the court suggested that before accepting delivery, the customer should reasonably have been expected to ascertain the nature of the conditions of sale and reject them if they were not considered acceptable. Now that's relatively unusual, I have to say. Normally, the onus is on the supplier to make sure that they have sufficiently brought their terms and conditions to the attention of the buyer before the contract comes into existence. And failure to do so could mean that your terms and conditions are not incorporated. And if that happens, what you will find is that you effectively potentially have a contract simply based on common law. In other words, your terms and conditions will not apply. And that could be particularly important both for things like warranties, but also things like limitations of liability. If you want to limit your liability in some way and you've not validly incorporated your own terms and conditions, then the likelihood is there will be no limit of liability and you'll potentially have unlimited liability for your contracts, which could be extremely important in an IT context. What the court said was that in this particular case, however, Jowett, which was the seller, was entitled to assume that by accepting the delivery with notice of the conditions of sale and not objecting, the customer did accept the terms and conditions were applicable. And the point I would make if you're acting for a customer is if the supplier makes any reference to their own terms and conditions and wanting them to apply, you should take some active steps to investigate what the terms are and object to them if necessary. Next, on the topic of forming contracts, I just want to illustrate a couple of cases which show how easy it is, particularly in this day and age, for parties to find themselves in contract. And particularly in circumstances where we have email communications these days, there was for a long time quite a lot of doubt as to whether you could form a contract simply via email. And the courts have been very clear in the last 12 to 18 months in making clear that email communications are perfectly valid for the purposes of forming binding contracts, at least under English law. There are very few, if any, formalities for forming ordinary commercial contracts, particularly in an IT context. And the Umrich against Gill case is an example of this. Now, normally, in order to create a deed, there has to be what's known as delivery. And the question was whether a guarantee that was signed, scanned and emailed was sufficient to constitute delivery for the purposes of making the contract binding. Now, the guarantor argued that the guarantees were not sufficiently delivered, but the court said delivery is the act of signifying that the giver of the deed intends it to be effective, and they regard themselves as bound by it. Now here, the court upheld the enforceability of the personal guarantee. What the court said, and again coming back to the objective assessment of the conduct of the parties, the court said that the act of signing, scanning and emailing the signature pages of the guarantees would lead a reasonable recipient to understand that the defendant had delivered the guarantees effectively and unconditionally. So, clear evidence they regard modern communications, modern email communications, sending emails as being binding. The court said in the age of instant communication, emailing a scanned signature page of an identified document is sufficient for delivery and would be unreasonable to expect a greater degree of formality. On a similar topic, the Cis case involved a contract for the sale of land. Now, normally contracts for the sale of land have to be in writing and they have to be signed by or on behalf of each of the parties to the contract. Now here, there was no physical writing, there was no physical signature. All that had happened were there were two solicitors representing the parties and they had exchanged emails confirming the terms of a settlement which involved the sale of an interest in land. The judge here concluded that in the current age, the notion of a signature would be capable of encompassing the wording in the footer of an email. So simply by appending your name and your contact details to the email was sufficient. The court said whether it was a signature depended upon whether the name was applied with what they called authenticating intent. And they said that even though the email footer was created automatically and added to every email that all the solicitors sent, creating that rule involved the conscious action of a person. And looked at objectively, the presence of the name indicated a clear intention to associate oneself with the email and to authenticate it, or indeed to sign it. So really just highlighting there that simply by exchanging emails, by sending an ordinary email, you can find yourself entering into a binding contract, even if ordinarily the contract might say, and some indeed draft contracts might say, that the contract had to be executed in writing. The courts clearly are prepared to do away with those restrictions, and therefore potentially you have to consider whether you expressly exclude emails from constituting writing. Some contracts do that, but in the absence of such an exclusion, emails will be sufficient to constitute writing. Almost certainly that's going to be followed in future cases. The next case I wanted to mention, moving on to the subject of time being of the essence. Now, you will often see contracts which say time is or is not of the essence. And this is a much misunderstood term, legal term. Very often I think people think that all it means is that time is important, but time of the essence has a particular legal meaning which is very significant. So I just want to talk briefly through the facts of the Ale Grove case. So this was a contract for the sale of a quantity of rice, which had a final date for shipment in December 2016. In the event, the full quantity of rice had still not been shipped by March 2017, despite repeated failures of the supplier to respond to chasing emails. Now here, the contract said nothing about time being of the essence. What the court said was that delays beyond the contractually stipulated date only give rise to a liability in damages. The law treats the time stipulation as being non-essential, and mere breach of it does not justify rescission or termination by the innocent party. an unreasonable delay amounting to repudiation is essential to justify rescission. So in other words, it's not just simply sufficient for a party to be a day late in performing a contract. There has to be a sufficiently unreasonable delay in order for the innocent party to be able to terminate a contract. What the court said was that following breach, the innocent party could have given a notice fixing a reasonable time for performance, and then had the supplier failed to comply with that reasonable time, then there would be an unreasonable delay, and that could justify a rescission. In this particular case, and this is something which I would particularly draw your attention to in the context of IT contracts, the court found that by the customer wrongly terminating the contract for delay, effectively, they were the ones that were in breach. And this allowed the supplier to claim damages, even though the supplier had failed to fulfill its contract of supply. So in other words, you have to be very, very careful to make sure that even if you are the innocent party, that you do not commit a fundamental breach by wrongly terminating a contract. You have to be very clear that you have sufficient grounds to terminate. But coming back to this phrase of time being of the essence, as I've said, it's a much misunderstood term. Why should suppliers object to time being of the essence? Well, the reason for that is that basically, if time is of the essence, a delay of only 1 day could be sufficient grounds for terminating a contract. That is effectively what time of the essence means. And that's why, in most cases, time will only be of the essence if it's expressly stipulated. It won't be implicit. So if you want to make time of the essence, then say so explicitly. But I would say from a supplier's perspective, time being of the essence is really quite dangerous in an IT context. Equally, if time is of the essence, beware of waiving that stipulation inadvertently. It could be that by continuing to chase performance and not reserving your rights to terminate, you could actually be waiving the time of the essence stipulation. So here an example. So this was a contract which contained a provision which said time for delivery of works or provision of the services is of the essence. The contract also said that the buyer may terminate this contract with immediate effect where the supplier commits a material default. So that's a pretty standard express right of termination. The point to note here is that effectively, by stipulating that time is of the essence, there is a significant risk that there are 2 parallel rights of termination. In other words, there's the express right of termination under the contract, but there is also a parallel right of termination at common law, which could mean that the supplier is liable to having their contract terminated if they're simply a day late in fulfilling the contractual obligation. Now, the next topic I want to talk about is this concept of reasonable endeavors, best endeavors, or in this case, best reasonable efforts. Now, these are phrases which are often included in various IT contracts of one form or another. The particular wording that I've taken here actually is from the contract that the European Union signed with AstraZeneca for the supply of COVID-19 vaccines. Now, you can read the definition for yourselves, but this was basically what they defined as best reasonable efforts. And this was the degree of effort that AstraZeneca had to exercise in fulfilling their contract. Now, you'll remember that the European Union said that AstraZeneca's contract was a binding one, an absolute contract, an absolute commitment. And looking at the contract, it seems to me it's quite clear that that was not actually the case. And in fact, there was a judgment the other day which would support AstraZeneca's position. But the reason I mention this case is that, as I say, best or reasonable endeavours commitments are fairly typical in IT related contracts. The point here is that the name of the definition or the title of the clause, whatever, however it's described, is irrelevant. The nature of the commitment that's being given here depends upon the precise words used. So here, the precise terminology that the parties had agreed to describe the nature of the commitment given by AstraZeneca. I would just make the point that in defining best reasonable efforts, the parties, for some reason, and I'm not sure why, made no reference to the fact that AstraZeneca were actually giving this commitment, but agreeing not to make a profit out of the contract. It seems to me that is a relevant factor in determining whether you've complied with your reasonable endeavours commitment. But looking at the definition that they came up with, it seems to me this was only ever a commitment by AstraZeneca to try to fulfill the supply of the vaccine. It was not an absolute commitment. And as the European Union found out, such commitments are in reality incredibly difficult to enforce because of their inherent uncertainty. Now, before I just sort of summarize my thoughts on these types of clauses, I just want to mention another case, which was an IT case. And it's one that I'll come back to in this session because it's really a very important case we've had in the last 12 months. That's the CIS case against IBM. In this particular context, IBM warranted and represented to the customer that they'd taken all reasonable steps, including making all appropriate inquiries and obtaining all appropriate professional and technical advice to satisfy itself as to the risk, contingencies and circumstances to do with its performance of the agreement. Now, it was alleged by CIS in this case that IBM had failed to take those reasonable steps. What the judge said about this was he said, I do not accept that an obligation to use all reasonable endeavours is necessarily the same as an obligation to use best endeavours, although in many cases there may be no discernible difference in practice. The judge then went on to say that although an obligation to use best endeavours is likely to encompass all reasonable steps that could be taken, it might extend to more than an accumulation of moderate or sensible steps. It's conceivable that the circumstances of a particular case could require the party with such an obligation to go further, such as taking steps that were against his own financial interests, or steps that required extraordinary efforts. And it said such steps are unlikely to fall within the scope of a reasonable endeavours obligation. The court said that authorities provide helpful guidance as to the meaning of all reasonable steps, but you have to interpret the words as part of the agreement in each case. So the scope of all reasonable steps must be considered in the context of the particular contract and taking into account the expert evidence as to the reasonable steps that could and should have been taken. And it was held here that IBM had not broken the warranty and that they had taken all reasonable steps. So concluding on this topic, I just want to make the point that whether you've got a best endeavours clause or a reasonable efforts clause or a best reasonable efforts or whatever formulation you've got, such clauses are very difficult to enforce. They are necessarily vague, and in my view, their use should be limited. I think it may be sensible to include an explicit definition. As you'll see here, the English courts are not particularly clear or consistent as to what these best or reasonable endeavours mean. And certainly, so I would just highlight here, for example, the courts do here, for example, in the context of a best endeavours commitment, they describe what it means with reference to what was reasonable steps. They also were not clear about whether a party had to actually go against their own financial interests. And I think those things should be made clear as part of a best or reasonable efforts definition. So I would certainly advise that it is sensible, if you're going to use this terminology, to make sure that you have a clear definition, and it's one that I've used in the past. The next general area I want to cover is in relation to a topic which is called relational contracts. Now, this is something which is entirely new for English law contracts, but it is some terminology that the English courts have begun to adapt or adopt in the last, well, probably the last 5 or 6 years. It involves the classification or the potential classification of a contract as a particular type of contract, one that the courts have described as being relational. And why is this important? Well, the suggestion is that if you have a relational contract, the courts will imply an overriding duty of good faith, and also something called a Braganza duty, and I'll come on to describing what that is in a minute. Now, the English courts have traditionally not imposed or implied obligations of good faith on contracting parties. That is very different from the traditional position under civil law. Now, English courts, as in many American jurisdictions and lots of the Commonwealth, apply common law principles, which is essentially based on court judgments. That's quite distinct from civil law jurisdictions that have commercial codes. Now, civil law jurisdictions are typically lots of continental European jurisdictions where the parties, almost as soon as you get into contractual negotiations, are obliged to exercise a duty of good faith towards each other. Now, we've never had that under English law, and that is extremely important because English law basically says that the express wording of the contract is more important, and it's that is generally given effect to. Now, I do just want to describe what's meant by the Braganza duty of rationality. Now, this comes out of a particular case from a few years ago that went by the name of one of the parties. It was called Braganza. And what the court there said was that where a particular clause confers a genuine discretion on one of the contracting parties in relation to a decision, it's a well-established contractual principle that such a decision must be taken in good faith and not in a way which is arbitrary, capricious, irrational, or perverse. In other words, there is a requirement of rationality. Now, this is a specific exception under English law. It's not of general application, but it does apply in very limited circumstances. So, for example, it might apply to a situation where a party is asking for consent from the other party. It might be consent to assignment, for example, or consent to the appointment of a subcontractor. And what this really means is that the decision making, the decision whether to grant consent or not, has to be taken on valid grounds. The consent must be either given or withheld for the right reasons. In other words, you can't withhold consent if you're trying to engineer some other, perhaps you're trying to engineer a termination of the contract, for example. You can't exercise that withholding of consent on grounds for which that consent was never intended. Equally, if you take account of factors which you shouldn't have done, then you might find yourself in breach of this duty of rationality. One final point, just to explain the scope of this duty: it doesn't apply to the exercise of absolute contractual rights. In other words, you're free to exercise an absolute contractual right, such as the right to terminate a contract. You don't have to do that rationally or otherwise. if you want to terminate a contract and you have the right to do so, you can do that however irrational the decision is. The Braganza duty of rationality does not extend that far. So just going back to this emergence of relational contracts. So a few years ago, there was the first case which said that for a contract involving a high degree of mutual trust and confidence, that could be defined as a relational contract. Now, these contracts would generally, at the time, in the cases where this came up, they tended to be contracts which were written on the back of an envelope. In other words, they were not professionally drawn up. They were not drawn up with professional help. They were relatively brief, almost outline contracts. And in the case of these relational contracts, the court said that they were more likely to apply an obligation of good faith. And also that the parties had to refrain from conduct which in the relevant context would be regarded as being commercially unacceptable by reasonable and honest people. Also, there was a suggestion that relational contracts would be interpreted more flexibly with less emphasis on the precise wording used. Now, this really reached its high watermark in the case of Bates against the Post Office in 2019, when the judge said the cases make it clear in my judgment that the concept of relational contracts is an established one in English law. And that case followed on from the Amy against Birmingham City Council case, a Court of Appeal case in 2018. In the Amy case, the court said a relational contract of this character is likely to be of massive length. Now, this was particularly important, as I say, because the earlier cases had been thought of as being relative outliers, relatively limited to where the cases involved contracts which were very small in size, had not been prepared with the assistance of professional advice. The Amy case was very distinct from that, and it seemed to represent a massive expansion of this principle of relational contracts. Now, why was that important? Well, it was important, as I've said, because it suggested that you could imply a duty of good faith across a whole range of contracts, even ones that had been professionally drawn up, even ones that run to many hundreds of different pages. It also suggested that contracts that were truly described as being relational would be implied in a more casual manner. So there would be a lot greater freedom for the courts to depart from the express wording used in the contract. And this was thought to be quite a worry for many lawyers, particularly because having taken great care to carefully draft your contract, this was seen as an avenue to giving the judges a lot more flexibility in terms of deciding what the contract did or not require the parties to do. Now, I have to say, over the last 18 months or so, we've seen a whole succession of cases where one or other of the parties has sought to argue that their contract was a relational contract, that there was a duty of good faith. So, for example, the Wales case, in that particular case, the court said there is a duty to act honestly, and that duty underlies all contractual relationships. However, the court said it would be inapposite to superimpose wider terms in relation to commercial standards of fair dealing. In the demand media case, the court said the test for the implication of terms do not differ as between relational and non-relational contracts. Now, that's very important. These cases were the first to sort of start to redress the balance, as it were, to stop the courts going down this route of expanding the scope of relational contracts to a much wider group of cases. Likewise, in the Britannia against Rockrose case, the judge said, I'm content to treat the contracts in question as being at least arguably relational contracts. However, that does not lead to the conclusion that it's necessary to imply a good faith obligation into the exercise of the particular power in question. In the Russell and Cartwright case, the court said there was no general duty of good faith which could be implied into the joint venture agreement on the basis that it was not essential to do so. Now, again, both of these cases going back to a much more traditional view of the world under English contract law. Similarly, the Cathay Pacific against Lufthansa case. Now here there was an option which Lufthansa, I think, had to reduce the scope of their contract. And the court said the option was not qualified by way of implication or by way of additional wording which had not been expressly included, or by an implied term, preventing one party from acting in an arbitrary and or unreasonable manner or requiring it to act in good faith. The court said the law on relational contracts has not yet reached a stage of settled clarity. And it was particularly relevant here that there were some clauses in the agreement where the parties had expressly provided for an obligation of good faith. And that was one of the reasons why the court said there wasn't a more general application of this duty of good faith. Two more cases, the Apache North Sea case against Ineos. The court said even long-term contracts which are properly to be classified as relational are likely nonetheless to be risk allocational, and the normal approach to interpretation should apply. Again, really watering down this principle of relational contracts. In the Essex against UBB waste case, the judge said, I reject out of hand the argument that any contractual duty of good faith could possibly stretch to requiring the council to renegotiate key standards at the heart of the contract or to give up its contractual right to hold UBB to the party's bargain. In other words, the written contract would be given effect to. The court said there was no scope for a Braganza implied term where a party was exercising an absolute contractual right, such as the right to terminate. Although rather confusingly, the judge then went on to say, this 25-year PFI contract is a paradigm example of a relational contract in which the law implies a duty of good faith. So very mixed messaging coming out there. So what can we conclude in relation to these relational contracts and the duty of good faith? Well, certainly the Braganza duty does continue to demonstrate that it is alive and well. So if you are in a situation where you have a discretion, where the contract grants you a discretion, as I say, perhaps in relation to assignment or in relation to some other factor, then you have to make sure that you exercise it on the right grounds and taking into account the right factors and for the right reason. If you fail to do so, you may well find you're in breach of contract. Relational contracts are still recognized. The courts do still refer to them, but the courts are much less willing to imply general duties of good faith or imply that other terms have been implied. As I say, we did see that high watermark, and the courts are now, certainly in the last 18 months or so, have been stepping back from that expansion of the concept of relational contracts. And it remains to be seen what happens to this line of cases as we go forward. Now, in the last 15 or 20 minutes or so, I really want to look at questions of liability and remedies for contractual breaches. Now that's a key topic in relation to IT contracts. And one of the key topics particularly is in relation to limits of liability, financial limits of liability. Many IT suppliers limit their liability with reference to the price paid. And as the BA Kitchen Components case illustrates, that may be dangerous. Now here, in this particular case, the seller said that in the case of a breach of contract, they were entitled to replace the goods free of charge, or at the seller's discretion, refund the price of the goods or the proportionate part, but otherwise the seller should have no further liability to the buyer. Now, this was a contract which was on the supplier standard terms, and although generally under English law, the contracting parties are free to stipulate whatever terms they want in their contract, one of the primary exceptions to that is what's called the Unfair Contract Terms Act 1977, commonly known as UCTA. Now, UCTA provides that where you have an exclusion or limitation clause, either in the supplier's standard terms and conditions, or an exclusion or limitation relating to liability for negligence, they are subject to a reasonableness test. And if the limitation or exclusion fails the reasonableness test, the limitation or exclusion will be unenforceable. So here the court had to consider whether that limitation or exclusion satisfied the reasonableness test. The court observed that this condition of sale was not particularly onerous or unusual, that the respective bargaining strengths or resources of the parties were not particularly significant factors, and also that the seller's limitation clause was common practice in the industry. Finally, the court said that the buyer ought reasonably to have been aware of the clause, so they were aware of the existence of the clause. You might also have thought that given that the buyer's own conditions of sale limit liability to the value of the goods that they supplied, that this clause might have been upheld. And indeed, the seller argued that it was reasonable to limit liability in this way because the potential losses that the buyer might suffer might be wholly disproportionate to the selling price, which were merely a component of the overall finished kitchens that were being manufactured. So for all those factors, you might have thought that the court would have upheld that limit of liability. But in fact, the court held that the clause was unreasonable and unenforceable. One of the key factors in this case was, according to the court, the fact that the supplier did and had obtained insurance against the risks that materialized in the present case, and therefore said that it was more appropriate that the risk of loss from the defect should fall on the supplier. Now, I have to say that that course does somewhat go against the recent trends of courts upholding limits of liability, and therefore it remains to be seen whether it's something of an outlier. You can't necessarily just pick one case and say that is determinative of what would be found in another case coming forward. But nevertheless, it does increase the risk that a future court might follow that judgment. So what can you do about it? Well, you could find that accepting a small multiple of the sums paid might increase your chance of the clause being upheld as being reasonable. It's becoming more common these days to see a multiple of perhaps 125% or 150% of the value of the contract as being the limit of liability, and that could be a factor in determining whether a court upholds it as being reasonable or not. I'd also make the point that although the judges felt that the presence of insurance was a key factor in their decision, the judgment made no discussion, didn't talk about what impact the judgment would have either on suppliers being able to obtain insurance or what the cost of insurance was likely to be in the future. For the courts, basically the mere existence of the insurance seems to have been the overwhelmingly decisive factor. Now that's really critical in an IT context because many IT suppliers and service providers will have professional indemnity insurance. And that could mean that actually they're potentially shooting themselves in the foot because they're raising the risk that these liability limitations might be declared to be unreasonable. Whilst on the subject of limitations of liability, I just want to talk about data security breaches because this is undoubtedly one of the really hot topics that I find I'm coming across increasingly when negotiating IT contracts. Now, first of all, the question is, should a data security breach be the subject of indemnity or not? One finds increasingly, I find in contracts that are drafted, that buyers are looking for an indemnity in respect of data security breaches. I have to say, I think from a supplier's perspective, an indemnity is dangerous. It's effectively like writing a blank check almost. It's particularly dangerous because it can be argued, depending upon the wording of the indemnity, that it's much broader than simply a claim for damages. Indemnities are enforced according to the specific wording of the drafting. So depending upon the wording, it could be that it makes you liable for all types of contractual liabilities. The other thing is, of course, if a buyer has an indemnity and suffers a data security breach, then arguably they have no incentive to try and limit their losses. And that's why I think they're particularly dangerous. I think it's also worthwhile saying, and it's something which I often find in contracts, if you do give an indemnity, but there are also limitations of liability, you have to be very clear whether the indemnity is subject to the limitation of liability or whether it overrides the limit. Very often you'll have an indemnity and you'll have a limit of liability, but it's not expressly stated which one takes priority. And that's a recipe for argument and dispute, basically. So assuming that you've managed to negotiate out an indemnity or you've included an indemnity, what cap on liability should I apply in my contract? Now, I have to say that I've found a whole raft of different practices here. Some contracts just have the ordinary cap on liability, whether it's 100% of price paid or 125, 150%, etc. But it is becoming more and more common that you have a separate so-called enhanced cap on liability, which applies to data security breaches. And then you get the question, well, at what level should that enhanced cap be? And I've seen anything from £1 million up to a maximum of 17 million. Now, I think the 17 million figure was proposed and does apply in a number of public sector IT contracts, because at least on one basis, that's the potential maximum fine under data protection legislation. Actually, as it happens, it's not the maximum fine, because it could be that for particular breaches, the cap on liability or the cap on fines is actually determined according to your annual aggregate turnover. But I make the point that there is a big variation in what people drafting contracts are seeing here. And I think it's worthwhile having a discussion as what is an appropriate level. If you've got a contract where the value of the contract is maybe £500,000 and the amount of profit that you're making maybe £200,000-300,000, is it really realistic for you to bet the company on a potential liability for breach of data security of 17 million? I think that may be unrealistic. And also, I've seen a number of contracts where the data security breaches are entirely uncapped, irrespective of whether they have an indemnity or not. And I think for IT suppliers, that's incredibly risky, particularly seeing the prevalence of fines for data protection breaches that we're now seeing beginning to come through. One of the other topics that is very pertinent for IT contracts are the meaning and impact of phrases such as exclusions of consequential loss. And approximately 12 to 18 months ago, we had the Sony case, which involved an exclusion of liability for indirect or consequential loss. Now, again, as I talked about earlier, with time being of the essence, exclusions of liability of consequential loss are commonly misunderstood. If you have a liability exclusion which excludes consequential loss, it has a particular legal meaning, and basically it excludes very little in reality. It certainly does not exclude liability which might be regarded as being direct, and liability which would be regarded as being within the reasonable contemplation of the parties at the time that the contract was entered into. So if you are simply relying upon an exclusion of indirect or consequential losses, it will exclude relatively little. Now here, that was what happened in the 2 Entertain against Sony case. This was the exclusion clause. So it excluded indirect and consequential loss. They'd also excluded liability for loss of profits, but only as a subcategory of indirect or consequential losses. And that's a very dangerous way to draft your exclusions, because basically it only excludes loss of profits which are regarded as being indirect or consequential. And it's very clear, the courts have been very clear in past cases, that loss of profits can be, in appropriate circumstances, a directly arising loss. Now here, the court found that the fire in question was not something which had arisen because of circumstances beyond the warehouse owner's reasonable control, and therefore they were liable for breach of contract. Now 2E, which was a division of the BBC, claimed for loss of profits. And the court said loss of profits and business interruption costs claimed do not constitute indirect or consequential loss or damage within the meaning of the exclusion clause. The direct and natural result of the fire was the destruction of the goods causing lost profits. Therefore, the claims in question in this case do not appear to fall within the scope of the exclusion. So I cannot emphasize highly enough, if you want to exclude liability for loss of profits, do so explicitly. Do not exclude liability for loss of profits as a subcategory of indirect or consequential loss, because it simply will not exclude those losses that arise directly and that were reasonably foreseeable. Interestingly, in that case, there was a liability, a financial limit on liability under the contract set at £5 million. And that was accepted by the parties as being an effective cap, despite the value of the contract, where the sales value of the stock in the warehouse at the time of the fire was valued at £40 million. And also despite the fact that the service provider was obliged to arrange insurance to a value of £10 million. So it does show you how different cases do come to different conclusions sometimes. Now, I just want to come back to the CIS against IBM case again, which, as I say, was the biggest IT-related case that we've had this year. And this was important for a number of different reasons. So the IBM case involved a master services agreement covering implementation and ongoing managed services relating to a new business administration system. IBM missed some key milestones, and CIS rejected an invoice claiming that a milestone had been achieved. Because of that rejection of the invoice and because of the non-payment, IBM purported to terminate. CIS accepted what they claimed to be a repudiatory breach by IBM, and they brought the contract to an end. In other words, they terminated. Another example of a contracting party terminating wrongfully and finding themselves in breach of contract. So CIS claimed damages. Now, it was held that IBM was in breach for failing to keep CIS properly informed of progress. Now, a couple of things here. First of all, IBM was not fixed with its subcontractors' knowledge. There was some evidence that a subcontractor knew that they were getting behind with the contract, that they were going to fail to be able to comply with the contract. And CIS had argued that IBM were under an obligation to notify just as soon as the subcontractor knew of that. The court decided that wasn't the case, and I will come back to that point in a minute with regard to some drafting points. What the case also evidenced was that witness evidence demonstrated the value of keeping good contemporaneous records of meetings that took place. In many IT disputes, there will be, or indeed in many in every IT project, there will be numerous meetings between the parties. One of the problems that IBM had here was that there was not good written evidence of what was said within the meetings. I would always urge parties to keep good minute taking of records of the meetings that that take place between the parties, because it's difficult enough remembering what you had for lunch, let alone what happened in a meeting 3 years ago when the dispute comes to court. So it's a very important lesson to keep good records of meetings. CIS brought claims for £128 million worth of damages based on wasted expenditure. They also brought an alternative claim based on additional expenditure caused by the delays, totaling some 27 million. Now here, IBM had excluded liability for indirect or consequential loss or loss of profits, so they excluded their liability in the right manner. As I say, CIS claimed for wasted expenditure, but somewhat surprisingly, the judge said that the loss of profit exclusion excluded CIS from claiming on the basis of wasted expenditure. The court said that loss of profit excluded the claim for wasted expenditure because wasted expenditure was loss of profit by another name. Now, I have to say, I find that's a remarkable conclusion. As a result of that, CIS was only able to recover about 16 million in respect to the additional costs they incurred prior to termination, which they would not have incurred had IBM met the contractual milestones. Now, both sides are believed to be considering an appeal, and this case is really quite exceptional because historically, the courts have tended to give a very narrow interpretation to very general exclusions of liability. What does this mean for both suppliers and customers? Well, for suppliers, what it means is that a loss of profit exclusion may be a lot broader in scope than you would ever have imagined. I have to say, I think the case, well, I would be surprised if the case wasn't appealed, and I would be surprised if it doesn't get overturned on appeal. But for the time being, loss of profit does exclude claims for wasted expenditure. What this also means is that for customers, you'd be well advised to include language which qualifies any loss of profit exclusion. Now, for those of you who are familiar with UK government contracts, they will often see language such as this, which says subject to and notwithstanding clauses excluding indirect and consequential loss, the customer may recover in terms of the clause as stated, including additional operational expenses, wasted expenditure, etc. And I think we will find that wording becoming more typical if there's a loss of profit exclusion contained within the contract. I've highlighted some wording in yellow here. I have to say this is wording which is used by Crown Commercial Services and is fairly typical, becoming fairly standard now. I have to say from a supplier's perspective, I don't like it because I think it amounts to an indemnity by any other language. Although it doesn't say that it's an indemnity, it effectively acknowledges the customer can recover these types of losses. Whereas I would prefer to see a statement which says, we acknowledge that the loss of profit exclusion does not exclude these types of losses, which would mean that the customer still has to prove that these losses did arise as a direct and natural result of the breach of contract. I did say that I would come back to the point about the knowledge of IBM and its subcontractors. The contract provided that IBM would be liable for the acts and omissions of its subcontractor, and that's perfectly standard, that's perfectly reasonable. The contract also contained a statement which said IBM was obliged to notify the customer when it became aware of any development which may have a material impact on the supplier's ability to provide the services effectively and in accordance with the agreed timetable. What the court said was that this drafting did not expressly or implicitly impute to IBM knowledge on the part of its subcontractors. In other words, even though the subcontractor knew that it was going to be in breach of contract, IBM was not automatically in breach by not notifying at that point. And what I think we may see as a result is, and certainly I would consider including this in a contract if I was acting for a customer, I would say something like the knowledge of any subcontractor should automatically be deemed to be known to the supplier for the purposes of this agreement. In other words, the supplier can't avoid liability simply saying, I didn't know something that my subcontractor did know. Finally, I just want to talk on the subject of penalties. Now, penalties can arise in the form of what might be called liquidated damages or service credits. In other words, they are a predefined remedy which applies in the event of a breach of contract, whether for delay or a breach of a service level agreement or whatever. Now, it's traditionally been the law, and many of you may know, that something which constitutes a penalty is unenforceable under English law. So if a penalty specified in a contract is more than the parties could reasonably have expected the greatest possible liability to exist, then it will be unenforceable. Now, that's the traditional formulation in which the courts have determined whether a service credit or a liquidated damage amounts to a penalty. But we've seen in recent years the courts have been far more generous in allowing contractual provisions to be given effect to, and it's only in very, very rare cases they will declare that contractual provisions are penalties, particularly in negotiated contracts. And this is really highlighted in the case of de Havilland against SpiceJet, which was a contract for the sale of aircraft. Now, what happened was the customer stopped making payments, the supplier terminated and claimed liquidated damages as per the contract. The contract provided that for each terminated aircraft that the purchaser had not paid for, they were liable to pay damages in the sum of $2.5 million US. There was wording which said this does not constitute a penalty and that the level of damages was agreed as being reasonable. The question came before the court, was this an unenforceable penalty? The court basically said no. And the court said the parties were both represented by sophisticated and experienced lawyers. They were substantial commercial operators with a long-standing commercial relationship. And the court said that they had comparable bargaining power. It also said that the buyer had not come close to casting doubt that the stipulated sum falls below, I think it should actually have said above, the highest level of damages that could possibly arise from the breach. But what is interesting is this last statement. So the court basically said that the test for a penalty is whether the clause in question is an exorbitant or extravagant pre-estimate. So it's not just whether it's reasonable as a pre-estimate, it has to be exorbitant or extravagant. And this was again repeated in the Permavent against Makin case, where the court said the question is not whether the detriment is harsh or even extremely harsh, but whether it is extravagant, exorbitant, or unconscionable as being out of all proportion to the protected interest. Now, what does this mean? This basically means that if you negotiate a contract which has some form of liquidated damages in it, it's now much more likely that the courts will give effect to it. Whereas historically you might have felt, well, I'll agree to the language because if necessary, I can go before a court and they're likely to declare it a penalty. Now that kind of argument is a lot less likely to be able to be available to a contracting party. And therefore I would suggest if there is a contractual provision that you feel might be a penalty, you really do have to negotiate the service credits or liquidated damages to a level you feel comfortable with, because there is a high possibility that the courts will give effect to the express language of the clause. And on that note, I will end my presentation and open the floor to questions.
Hi, Paul. There have been already some questions in the chat. So I will start with number one. This was quite early from Ismailia Jabank. Okay, just 2 words, due diligence, but it was referring after the IBM case, the slide with best reasonable endeavors. So Ismailia, would you like to raise the question yourself? So the question is, if there is due diligence, it was placed on the slide with best reasonable endeavors. Anyway, in the absence of response, I will just move on to the next question from Patrick Carey about data security breaches. How does the liability level compare with US? How is the English situation affected when the service provider is multi-jurisdictional and that data could be in US, in EU, or in both locations? So that's the next question. I don't know if Patrick wishes to take the floor to complement.
Thank you, Panyata. I mean, yeah, you read my question. What I would say is that in terms of claims around liability for data security breaches in the United States, the amounts are far, far higher than the amounts that we were just discussing a moment ago. And there are serious questions as to whether the existing levels that we have based on ICO's ability to fine potentially is adequate in the circumstances. But that really wasn't the core of my question. The problem is that so much of the data that we're dealing with today is accessed within the US or within EU or both in many, many business dealings. And it is rare these days to find constraints that limit the holding of data that could be at risk to the United Kingdom.
Paul?
Well, I mean, clearly that is, I mean, what you've said is absolutely factually correct. You do need to analyze in whatever contract you're doing what the risk is of, you know, an international data breach. It may be that there's one particular breach, but it affects customers across different jurisdictions. And obviously there is a possibility that damages could be suffered in different jurisdictions, and indeed fines could be levied by American regulators as with European regulators at the same time. So this is an area of real practical risk for IT suppliers and for their customers, because you know, it is a real concern that you could have a relatively small contract, but the consequences could be absolutely enormous. And the question is, how do you apportion that risk? And
may I ask as a supplementary, which is because I don't want to hog the limelight, but is this an area of interest to you? Because I have some very specific things, and that were you interested, I would be very happy to have a separate call, ping you an email or whatever.
No, please do, because I think it's a topic which is only just coming to, you know, people are only just appreciating the consequence of this, and it remains to be seen how this develops. You know, and as I showed on the slides, I think there are rapidly diverging perspectives. Some people want completely unlimited liability. Other people are not prepared to accept, you know, only very limited levels of liability. So
absolutely.
I think it's very much an evolving area.
Thank you.
Then the next question is from Stephen Castell, who is also one of our specialist group members. Did CIS also claim in tort for lack of reasonable professional skill, care and diligence on the part of IBM? And if not, why not? And I don't know, Stephen, if you wish to take the floor to complement the question raised. Otherwise,
yes, thank you, Panagiotta. Yeah, I think that is the question. I was slightly surprised to see, but I haven't studied the full pleadings or the case. I just wondered if Paul knew whether aside from wrongful termination and the challenges to indemnities for loss of profits, whether there was alternative pleading on a tortious basis for lack of reasonable professional skill, care and diligence on the part of IBM, where of course damages are at large. If not, I say why not, because I'm very used to seeing that as of normal in a big systems implementation like this.
I would have to say the judgment is fairly lengthy. I think it's at least, well, it runs into many dozens of pages. My recollection is I'm pretty sure they did claim on a tortious basis as well, but ultimately I don't think that made a difference to the claim, because it was generally acknowledged that the caps on liability would be effective no matter what basis the claims were brought under. So I think certainly from memory, they brought claims on just about every basis they could possibly think of.
Oh, okay, thanks. I mean, not again, normally, in my experience, a tortious claim like that you just sweep aside limitations and caps. It just doesn't, there are damages at large. Of course, you have to put up a case and have a model, often supported by expert evidence, as to why you are claiming a certain level of consequences arising from these lack of professional skill, care and diligence. But I wouldn't have thought the cap sort of involved. But anyway.
Well, I think
one needs to read the judgment.
Well, I think all I would say on that is you will find, as a matter of standard practice, most IT suppliers will expressly say that their caps on liability apply whether under breach of contract, negligence, or on any other ground whatsoever. So IT suppliers certainly go to, or certainly well-advised IT suppliers would try to cap their liability no matter what basis that the claim is brought under.
Okay, I don't want to get into what an argument, but my experience is that wording just doesn't stand up when you're bringing a tortious claim. I mean, you can argue that those words in the contract themselves do not apply when you are bringing a tortious claim. So it's irrelevant whether they're in the contract. But I mean, it needs to be argued, and you need to convince a judge, and it may be.
Yeah, no, absolutely.
You know, the tactics of arguing it, of course, when there's so much else going on as well. And as I say, you probably need to read the dozens of pages if one has got a spare half.
I would certainly recommend, if you're interested, to read the judgment, because it is.
I might well do that. Thank you.
It is fascinating, and it does raise a whole raft of different issues about IT contracts.
Doesn't it just? Thank you.
And also, as Stephen already had the floor, there was a second question from Stephen. Have there been any instances of punitive damages being awarded by courts in the US for data security breaches?
Yeah, I was just following up Paul's query on damages for security breaches. It just struck me, as we know, in the US courts, they have the ability to award punitive damages, which can be almost any figure they clutch out of the air. I just wondered if there had actually been any instances that anyone knew about of such damages being awarded purely for security breach infringements and liabilities.
I have to say it's not something I'm specifically aware of, but I think the previous questioner did mention the fact that some fines in America are can be very big. So, but I'm not particularly aware of damages claims in the US.
Okay, moving on to the next question from Tom 5. Would you normally want to exclude SLA service credits from LDs? And would that be an incentive rather than LD? So I don't know, Tom, if you wish to take the floor to complement your question.
Yeah, it's just usually when we're drafting up the SLA schedules, you'll see the suppliers coming back and saying that any service credits are considered as a part of the LDs, and we usually try and get that out so that all the remedies are available, on the client side. But it's a bit of back and forth there, really. What are you sort of seeing as the normal way of doing it these days?
I think the short answer is there is no one particular normal. I think that's the first question. There is clearly an argument to be had as to whether it's liquidated damages or service credits, whatever they are an exclusive or a non-exclusive remedy. Obviously, if they're an exclusive remedy, they effectively operate as a form of limitation of liability, both from the customer and the supplier's perspective.
Yeah.
And you have to be conscious of that. And as I've said, if you agree a formula for service credits or liquidated damages, it's likely that they will be enforced as such.
Yeah.
So if I was acting for a customer, you have to be wary of, if you are going to accept an exclusive remedy provision, I would generally say that it should be within a fairly narrow scope. You know, so for example, whereas you might be prepared to accept a service credit regime applying between 99.9 and 99.5% of availability, for example, I wouldn't accept an exclusive remedy if the availability went down to 85 or 50, because the potential damages that you could suffer from catastrophic failures of performance could be huge. So as I say, I think if you're going to accept exclusive remedies, I think they should be relatively narrow in scope.
Absolutely. Okay, that's good to know.
Tom, it's Sam here. I'd also add to Paul's sort of comment that, you know, whilst you can characterize service credits as liquidated damages, you could also characterize them basically as a reduction of the charges to reflect the lower value of the services you receive, and sort of and characterize them as that. And therefore you don't get into a debate whether they're liquidated damage, or well, you probably do get into a debate, but it's less of a debate because you've characterized them as outside the LD regime.
Yeah,
I think all I was going to say was there is another sort of slight issue with sort of service credits and liquidated damages type provisions. If you say that they are regarded as being a variation in the price, in that you potentially then invite somebody to say, well, the supplier, you know, has effectively a sort of menu of prices and they charge according to how they perform. You could then say that they're actually exercising a contractual right. In other words, they had the right to perform at 95% rather than 99%. And that could inadvertently prevent you from claiming damages. So you do have to watch that, I think.
Yeah. You usually the ones that we deal with, it's the well-known mechanism of, you know, at risk pool and all those good things. So it's a percentage of the monthly invoice. So, you know, the argument we always make is, well, that can't be limited because it's we don't know what the damage this might cause of you failing that SLA. Therefore, you know, it can't be a pre-estimate. It's just based on your billing. There is that potential incentivization, which should take away your profit margin. It's trying to balance those arguments. But yeah, good point. Thank you.
Thank you. Next question from Nora Mohammed. Does the force majeure clause in commercial contracts have adverse effects on whoever puts it? Nora, would you like to complement your question or read it yourself? If not, Paul, that's the question. If the force majeure clause in commercial contracts has adverse effects on whoever puts it?
Well, the one point I would make about force majeure, well, 2 points I would make about force majeure clauses. First of all, force majeure does not apply as a concept under English law unless you explicitly include a contractual provision to that effect. So, and that is very different. English law in this respect is very different from civil law jurisdictions. So under English law, if you want to seek the protection of a force majeure clause, if your contract does not have a force majeure clause in it, there's no general, it's not implied. So as a supplier, you have to think about including a force majeure clause. The second thing I would say is force majeure clauses take effect according to their drafting. So, and each contract will obviously therefore be different. So whether you have the protection of a force majeure clause or not does depend upon exactly how the contract is worded. The other thing I would say about force majeure is, force majeure is quite a sort of complex area, because particularly in an IT context, because whereas lots of people just include a very simple boilerplate force majeure clause, in an IT context, you have to give a lot of thought as to, there are lots of things which are potentially outside somebody's control, but it might be perfectly reasonable for them to have taken precautions to safeguard against the impact of that force majeure situation. So for example, there might be a failure of electricity supply, for example, but it's perfectly reasonable to expect the IT supplier to have had in place backup and recovery measures to have a spare generator, for example, to make sure the electricity supply is maintained. So I think in an IT context, it's well worthwhile giving a lot more thought than people have done historically to exactly what the obligations and rights and responsibilities of people are in a force majeure situation.
Okay, thank you, Paul. Next question from Olivia. In case of liability for low value services, not goods, contract, can liability be limited for the supplier to the excess of insurance taken out? This seems beneficial to the supplier. I don't know if Olivia, you would like to complement or raise the question yourself, adding certain elements. Otherwise, Paul, Olivia?
It just follows on from that discussion he had on liability, indemnity, data breaches. So there was the contract is for, let's say, data processing. And there was discussion on how much liability, what the amount of liability should be. It was also ruled out to not have indemnity clauses, because we thought if there was a data breach or something went wrong, then insurance might cover it, and therefore the liability was set to the excess or part of it, of the insurance. Is that a basis for thinking about how to set a price for liability?
What I would say is, I think it's incumbent on people, as it sounds like you did, to give some thought to how you set your limit of liability and take account of the insurance position. So I don't think there's any one particular right or wrong in terms of what the right level of limit of liability is. That will often be a matter for negotiation, but I would say it's quite reckless if you have some insurance in place and you don't take account of that when you're setting your liability limits. Just a couple of other things I would say. The first thing is insurance will typically not provide coverage on an indemnity basis. There is a risk if you agree to indemnify your customer that you will actually be extending your liability beyond the damages that you would have been liable for at law. And some insurers explicitly say that they don't cover you for those indemnities. So
yeah, we've decided, yeah, so indemnity is not going to be included. So we decided not to have indemnity clause.
I think from a supplier's perspective, that's certainly sensible.
Yeah.
Fixing the limit of liability with reference to the excess might be a sensible way of going about it. I mean, obviously, to me, I think far too much emphasis is placed on insurance, but the reality is that's what the courts are focusing on. and therefore it shouldn't be ignored.
So if you have insurance, you should set some amount of liability, is what you're saying.
Even if you have
Yes.
insurance, you still have to act. Most insurance policies, and I don't profess to be an insurance expert, but most insurance policies, the ones I've looked at, contain an obligation on the insured to act reasonably in limiting their liability. In
Right.
other words, you can't just say, we've got £5 million or £10 million worth of insurance. We can provide that to each and every customer.
Right. Yeah.
Because that is potentially exposing the insurer to more liability than they would have anticipated.
Yeah.
So you do have to demonstrate that you've acted reasonably. The other thing I would say is whatever decision you come to, it's worthwhile documenting your thought processes, because
Yes.
that can help justify why you reached a particular position.
Okay. That's been done, but thank you. This is helpful. Thank you.
Good.
Stephen comes in also with a relevant question. If liabilities and limits are going to be tied in some way to the insurance position, doesn't the insurer prudently have to become a party to the contract? That's what Stephen asks.
Yeah, sorry, that just arising from that last discussion, which sounds very interesting. It just struck me that one could be writing all kinds of things related to insurance in the two-party contract, and you just haven't actually checked with the insurer that any of that will stand up if it comes to be called upon. And does that maybe imply that if you're going to be really prudent, you should involve the insurer in at least in discussing the contract, if not actually becoming some sort of party to it? I don't know, that may sound ridiculous, but it just struck me.
I think what I would say, Stephen, is there's clearly no way an insurer is going to become a party to the contract, but I would say absolutely, if you have a particularly valuable or a particularly important or a particularly risky contract, you should certainly be consulting the insurance broker or indeed the insurer themselves to make sure that they are fully aware of the risk that you are taking on, because all insureds have a duty of sort of full disclosure towards their insurers. And the last thing you want to find is that they decline coverage on the basis that you haven't given them full and frank disclosure at the time.
I think just as a consultant, if your PI policy has similar wording in it, and of course we all go merrily on and take on a particular client, and the last thing you think of is, oh, I must just remember to go and just at least tell the insurer that I'm taking on this slightly unusual client in a slightly unusual country, maybe. Oh, hang on, does the policy actually cover that country? I mean, these are the sorts of things that you don't have burning in your brain every day of doing your
job. I
so
realise
it's
that.
A very good point, and it's a bit like we always say, the tax man is always your silent partner in any transaction. Probably you'll think that the insurer is the next one in the queue as well. Just following on from that, somebody else has asked one, but if I may, just because it just struck me, I don't know whether you said anything, I came in a bit late, on performance bonds, which were very much the flavour back in the sort of 70s, 80s, 90s. I don't know what the currency, it's a form of insurance from the part of the customer for the supplier, if he's likely to go bust or get bought out or something, to put up a performance bond at a bank, which is a kind of form of financial insurance. I don't know whether you covered that as being common now or not common. How common or not is it anymore?
It's not something I covered, but and I wouldn't say it's common, but I have seen it. So it still does exist in isolated instances, but it's not terribly common, I would say.
Okay, thank you.
Okay, moving a bit to another topic, Talula Fandago asks if a Californian citizen suffers as a result of a privacy breach, in which jurisdictions can they raise a case? It's a bit, Talula, would you like to complement your question? Okay, that's the question, Paul. So related to data breach of a Californian citizen.
Well, I think it's slightly off topic, but the reality is it will depend upon the facts and circumstances of the breach in question. So as one of the earlier people said, many data breaches have international aspects. So it will depend upon where the processing was and where the breach was that took place. So if you may be an American citizen that suffers, so almost certainly you'd be able to take action through the US courts, I suspect. But that doesn't mean to say that the Information Commissioner in the UK, if the processing was taking place in the UK, they may well take action there as well. So you could probably get involved in some sort of forum shopping to decide which jurisdiction was most advantageous to bring your claim. But not something I profess to be a particular expert in, but yes, I suspect you've got a degree of flexibility.
Okay, thank you very much. One question from me, again, a bit off topic, but in the slide that you mentioned, scanned signatures sufficient for a deed. Has there been a change in attitude since the qualified electronic signatures have been in place? I mean, in theory, there may be no reason why one would use scanned signatures anymore and not electronic signatures, and which can act as non-repudiation. I mean, it's so much easier to not deny them. And
I think all I would say there is the courts have shown themselves, certainly the English courts have shown themselves remarkably willing to accept just about anything as a signature. And let's be clear here, under English law, for an ordinary commercial contract, you don't need to sign a contract. So unless the contract says you need to sign it, but even if the contract says you need to sign it, the courts have demonstrated that they will accept just about anything as being a signature, even just an email footer. So it's going to be very unlikely that a court these days will rule that a contract is invalid for want of a signature.
Thank you very much. And just as a last remark, because Ismalia has been posting some remarks in the discussion of liabilities and limits, just a question to Ismalia, if you wish to take the floor to just complement with any comments. The last question written by Olivia and then Stephen. If not, then that was it, Paul. All the questions have been answered. Thank you very much, Paul. Thank you very much to Sam. I don't know, Sam, if you want to give the closure. Before, if Sam takes the floor, I would allow Sam to, as our chair, to give the closure, but I would just like to thank everybody and to let you know that the next event of the BCS Law Specialist Group will take place in July, 27th of July. David Eastwood, draft code of conduct for software audits. And I would welcome you all to be there, to have another nice event and speech. So leaving the last words to Paul, and then if some wish to close. Thank you very much from my side.
Paul, do you want to say something, or?
Well, all I was going to say was thanks for people's interest. Thanks for all your questions. If anybody has any supplementary questions or other questions that they want answering, I'm quite happy. If people want to send me an email, I'll do my best to answer them. But otherwise, thank you for your time.
Great, and I'll just say a few words. So thanks, Paul. I really appreciate your support here. And Panagiotis, thanks for, heralding the troops and doing the Q&A. I know that's always a bit of a challenging exercise, so thank you for that. And thank you all for attending and for engaging. Without you, this group wouldn't really be able to do these sort of presentations. It's because of you that we do these. So thank you for your support. And as Panajota said, stay tuned for the next one in July. And obviously, if you've got any ideas for any topics you would like our specialist group to cover, just email the email address on the specialist group, and we can consider that at our next meeting. So thank you, and be safe, and until next time. So thank you.